Hi everyone. Today I'm going to discuss a court case I recently read that rubbed me the wrong way because of the decision that was made and the logic and reasoning the court took. Now, the case is about expedited removal and the definition of entry. Just to start off, I don't practice in removal proceedings or appeals, and I don't usually deal with non-business or non-family based immigration. But I do study all the other areas of immigration law because of my strong interest in this area of law. And the way this decision was made bothered me. The case in question was decided by the United States Court of Appeals for the Ninth Circuit, the West Coast Circuit. The case name is Tellez v. Lynch, number 12-73424. The decision was filed on October 24, 2016. The facts of the case are as such. A young woman named Jessica Tellez went to the U.S. border at San Ysidro in 2000, claimed to be a U.S. citizen, but caught the suspicion of the immigration officers who took her to secondary inspection. There she admitted she wasn't a U.S. citizen and didn't have valid documents. This caused her to be inadmissible and she was expeditedly removed from the U.S. However, undaunted, she dressed up really nice and got in a car and tried to get back to the U.S. a week later and was waived through. Later on, in 2012, mistakenly, she applied for a waiver of inadmissibility and tried to adjust her status to have a lawful permanent resident. I'm guessing she was probably married to a U.S. citizen at that time. Now, the case would have to have been denied because she had unlawfully presented herself as a citizen, unless she could get out of that. But another issue that was argued here, which was the point of this case, was that the Department of Homeland Security reinstated her expedited removal order on the grounds that she had illegally re-entered the country. The arguments then made at trial by the defendant was that the reinstatement of the removal order was invalid because she didn't re-enter the U.S. The first time she tried to come and enter the U.S., she was stopped. It never actually had an entry. The reinstatement statute at 8 U.S.C. 1231A5 says, if the Attorney General finds that an alien has re-entered the United States illegally after having been removed or having departed voluntarily under an order of removal, the prior order of removal is reinstated from its original date and is not subject to being reopened or reviewed. The alien is not eligible and may not apply for any relief under this chapter, and the alien shall be removed under the prior order at any time after the re-entry. The Ninth Circuit here argues and decides that because she first entered the country, even though she didn't actually enter the U.S., this was a second re-entry which would allow the reinstatement of the removal order. Now, I understand the practicality of what they're saying, and the reasoning is essentially she tried to enter once and tried to enter again illegally, so she can't do it a second time, order is reinstated. But the law doesn't say that, and case law is very specific on this. The core of the issue is, did she enter the U.S. the first time that she came? Now, immigration lawyers know that if you're at a port of entry, you don't have any constitutional rights. You're not in the U.S. to be able to take advantage of those. Putting that aside, there was case law in Ninth Circuit as well that said that to have entered the U.S., physical presence alone is not enough, and it must be accompanied by freedom from official restraint. Thus, someone who's at the border in secondary inspection is still not free from official restraint and is not considered to have entered the U.S. So the concept of removal, which happens when a judge, an immigration judge, IJ, has a decision that deports someone from the country, is different from an expedited removal where a person is just not allowed in. Expedited removal comes from the idea of exclusion, of not letting the person even come into the country. Now, a lot of times the term removal is used, and the only argument the government has here, directly mentioning that they're not going to go by the definition of entry as used in common law and case law, is that the term removal means that someone entered and then they were removed, taken out. And they just base it on the dictionary definition. However, any practitioner of immigration law knows that the dictionary doesn't have a place in immigration law. Immigration law is a hodgepodge of random statutes that just grow constantly and change based on practice and case law and future immigration regulations from the Congress and from the executive and from the courts. So to just disregard all that, to base it on what their definition they see in a dictionary, which is completely unrelated to the craziness of immigration law, is completely unwarranted. This sort of disrespect by the Ninth Circuit for immigration laws and immigration case law is evident from the transcript of the oral hearings, where the justices don't even want to hear from the defendant's side. His attorney is constantly cut off in almost every statement he's making. And the judges don't even know immigration law. They ask what an NTA is, constantly throwing out opinions about what the law is or what these words mean without actually knowing complexity of immigration law. It's really obvious from the oral argument that they just didn't like the idea that this person would try to enter the U.S., be prevented, and then find a second chance to re-enter and not let them in. I appreciate their morality in not liking that, but that's not a place here when you base it on history of case law. When now you create a definition from history and you change it abruptly without much reasoning. When you do look at the regulations, such as 8 CFR Part 1235, inspection of persons applying for admission, and 1235.3, inadmissible aliens and expedited removal, it talks about attempts to enter as opposed to persons who were able to enter. So there's distinguishing between a person who entered and attempts to enter. And when you look at the verb removal, on its own it has one meaning, but when you add another word in front of it, expedited removal, that becomes a completely different term and a completely different legal process, which is the person who gets expedited removal has no way of getting judicial review of that decision. Whereas regular removal means going to court, having your day in court, having an attorney present, and having certain legal defenses that are not available necessarily at the border. Furthermore, when you look at the reinstatement of removal order statute in 8 U.S. Code section 1231, it talks about a removal order not being reviewable or reopened in any way. Such a strong language could only happen if the person had full hearing in front of the immigration judge, which is the removal procedure. But an expedited removal doesn't give those additional avenues to defend yourself. So a reinstatement order shouldn't have the same harsh effects. It should be a separate thing. This difference should be delineated, explained, and discussed properly in the statute, and it isn't. But if you go to case law and you see the definition of entry, such a person hasn't entered. And it's not fair to consider them as having re-entered and allow a reinstatement based on that. Now, this person in this case would not be able to get a lawful permanent residency, probably because of false claim to citizenship and other issues that probably exist. But now we have bad law in the courts and in the Ninth Circuit especially, which is surprising, that disregards previous case history. It's unfortunate, and that's why we have to be very careful when appealing certain cases, because we never know what kind of decisions are going to be put out by higher courts that are going to affect more than just that one case, but thousands and thousands of other individuals. Please let me know what you think. You can email me at info@jqqlaw.com or leave a comment on the bottom of my YouTube video page for this discussion.